Hello, my name is Roger Fontana. Today, I will be discussing the death penalty concerning how juveniles are treated in the justice system when the death penalty is brought into the conversation. For at least a century, juveniles were mixed with adults both when in incarceration and in the punishment given by the court. Almost every facet of these activities has been changed, whereby juveniles are treated differently depending on age and circumstances. I begin with an article that discussed a case that was brought before the court. In a journal article by Dominic J. Ricotta in the Journal of Criminal Law and Criminology, titled Eighth Amendment, the Death Penalty for Juveniles, a state's right or a child's injustice. He wrote that on June 29th, 1988, the U.S. Supreme Court vacated the death sentence of William Wayne Thompson, a 15-year-old Oklahoman found guilty of first-degree murder. The case was decided under the auspices of the Eighth Amendment's prohibition against the infliction of cruel and unusual punishment. After reviewing behavior of juries, statutes, and the disproportionality between the death penalty and suspect's culpability, the court determined the death penalty for this individual under 16 was too young to support executing. However, it was somewhat on a technicality, since the inmate was moved from a juvenile court to a criminal court and may even have entered into the domain of double jeopardy because he was moved from a juvenile court to an adult court. The backstory was that this young man and 3 others killed his brother-in-law and threw him into a river tied to a concrete block. The district attorney at that time partitioned the court to have him moved to the criminal adult court. It was already a practice that under 18 was a juvenile responsibility, with exceptions of 16 and 17-year-olds who are accused of separate crimes such as murder, kidnapping, extortion, and robbery with a dangerous weapon. After being convicted in the penalty phase, jurors could not commit that he would want to continue in this activity and be a continuous threat to society, which was a requirement that had to be accepted based on many factors, including background of the defendant and reasonable expectation. The jury fixed his punishment at death because they felt that there's severe aggravating factors for consideration, such as the defendant cutting the victim so the fish will eat him. The DA determined that there was no possible rehabilitation or salvation and was to stand trial as an adult for such a heinous crime. He may also be convicted of violating the Constitution, according to the belief at that time. What was overlooked is that the statement for avoiding the death penalty, the word child. This was the language thought applicable for the evolving standard. Further in the writing, the word childhood is mentioned in the plurality writing, which was creating the distinction between children and adults. The court added more support by citing the American Bar Association and the American Law Institute, who opposed the death penalty for any person under the age of 18 at the time of offense. This thinking pushed the left's viewpoint that restorative justice for all was possible, by which its very nature has rehabilitation within its concept of practice. Many cases followed. These cases were Blakely v. Washington, which limited sentencing before mitigating circumstances were given, and Graham v. Florida. The Supreme Court ruled that a life without parole sentence for a defendant who did not commit a homicide is unconstitutional for a juvenile offender. At that time, there were 77 young inmates in jail with that sentence. In Breed v. Jones, moving a child from the juvenile court to an adult court could not be done. In Miller v. Alabama, the court banned the mandatory life without parole sentence for juveniles. And in Jones v. Mississippi, there had to be a hearing to determine if there was probable cause to believe the juvenile committed the delinquent act and not be what appeared to be tried in the juvenile adult court. In the court's mind, that could be double jeopardy. Also, ancillary cases such as Warden v. Alvarado, Fair v. Michael C., and Schall v. Martin, which agreed that a juvenile can be held in preventive detention if there's an adequate concern that the juvenile would commit additional crimes, while the primary case is pending further court action. What can be learned from the array of cases, including the death penalty for juveniles, is that perspective of this punishment is being mollified by society, little by little. The juvenile's current past seems to be weakened by time and court decisions. Many cities today allow juveniles to rob without apprehension, murder without apprehension, riot, loot, carjack, and so on, while those who are employees are enjoined from taking part in arresting or restraining lawbreakers. Eventually, these will be corrected or society suffers.